Hi, this is Dr. Cora Strack again. Um, this is my final piece of work, I think, for the moment, and it has taken me years. And I think the first paper I wrote, I remember I couldn't sleep for 2 weeks. It was a paper that took me 4 years to investigate on the implementation of the Protective Disclosures Act and acts of omission, and it started by asking the question, what is an act of omission in law, and then that led to a further question, a further question, further question, and then a paper which, when I finished it, I wasn't able to sleep for a number of weeks. Um, I was so shocked, and it was so different from doing a mathematics paper, researching a mathematics paper, because it just followed the questions and just tried to get to the next stage and the next stage. And when I had it finished, I was just, it was an incredible situation that I couldn't sleep for 2 weeks. So I've been looking at this legislation for a long time, and I took a break from it, and I've come back to it in the last while again, and I've written several papers in the last couple of years on it again. So I'm having a look at the 2002 Act, and now I'm bringing all of this together again in this final paper for the moment, and it's called The Protective Disclosures Blind Spot, Why Whistleblower Protection is Failing in Practice. And I noticed from my analytics around the world, there were a lot of people very interested in what I have to say about protective disclosure. So this is the global issue, and the issues I raise are global challenges for constitutional democracies, human rights, and access to justice. So welcome to those of you who are interested in whistleblowing, and it's a huge issue. And I'm going to share a perspective which may not be very popular, and it is that I believe that whistleblowing protection, as it's designed at the moment, is unworkable. Because again of access to justice issues and the problem with representation, getting legal representation, I don't think, and also it's very adversarial, and when things are adversarial, institutions become extremely defensive, and what you get is more of a defence, like a battle between the whistleblower, and which becomes like a legal battle rather than trying to solve the problem. So again, I'm going to suggest that we need to have new vision here for our protective disclosures framework in the first instance, and if we can do problem solving rather than a legal battle, we might get further with sorting out the issues before they become into a major adversarial legal battle between the whistleblower and the institution. So this is just practical kind of vision that I can't see it working. I looking at the EU, all the EU acts and the EU protective disclosure legislation, and just looking at all the research I've done, and I believe it's actually unworkable for the majority of whistleblowers. There's a small number it may work for, but I can't see it working. So I think we need a new vision for how we look at protective disclosure legislation. This is and I'm saying that for a lot of justice issues, because I can't see that for all the disputes that are there at the moment, we have enough lawyers, or there'll ever be enough lawyers willing to take the side of the vulnerable, or the whistleblower, or the weaker, the one that's against the institution. I don't think they will get supported, using this model. So I think a problem solving a dispute resolution model, the state may be willing to support that, but I don't think they'll be willing to support, challenges against the state in the same way. So that's the way it has been. Perhaps it will change. So the protective disclosures blind spot, institutional protective layering, procedural displacement, burden reversal, and the future of whistleblowing protection in Ireland. So this paper examines a fundamental question. Why do whistleblower protection laws often appear strong on paper while remaining extraordinarily difficult to use in practice? The law may provide reporting channels, confidentiality, protection from penalisation, investigation procedures, compensation, and access to tribunals or courts. However, the reporting person may still be required to overcome a long sequence of barriers. They may have to prove that they fall within the correct legal definition of a worker. They may have to establish that the information arose from a work-related context. Their report may be reclassified as a personal or interpersonal grievance. They may ask to produce evidence controlled by the institution they have reported. They may encounter narrow terms of reference, delayed investigations, institutional conflicts of interest, short limitation periods, and the prohibitive cost of legal representation. Each barrier may appear defensible when considered separately. The problem arises when all of them operate together. The reporting person may begin with a formal legal promise of protection, but end with an internal grievance, fragmented legal claims, an expired limitation period, unaffordable litigation, and no complete investigation of the original wrongdoing. And this can make a whistleblower ill, and has made many whistleblowers ill, and very ill, and traumatised. We call this kind of secondary trauma, a huge amount of secondary trauma in whistleblowing, from the delays and the exhaustion and having to persist and all these obstacles, having to jump over all these obstacles. It's exhaustion in itself. It's, to me, it's a failed system. Just calling it's a completely failed system as it is designed at the moment. I describe the cumulative failure as the protective disclosures blind spot. The wrongdoing is not necessarily disproved. The reporting person is not necessarily told directly they have no rights. Instead, the disclosure may be progressively narrowed, divided, delayed, reframed, and processed out of legal visibility. You can see the correspondence with the constitutional blind spot. In fact, I would regard this as significantly worse, than the constitutional blind spot. You could say a constitutional challenge. A constitutional challenger is almost regarded like a whistleblower, which is shocking, but that's the way I see it. But when you look at the barriers that are in front now of the whistleblower, I mean, it's impossible for a whistleblower to succeed almost. It's even more impossible, I would say, than a constitutional challenger, even though I see that a constitutional challenger now is almost seen as a whistleblower when in a constitutional democracy. So there's a real correspondence here, but the whistleblower is facing an impossible sequence of barriers, particularly following the narrowing of so many rights, or gates in the 2022 amendment, as I've studied it, forensically for many months. So status controls entry, classification controls meaning, evidence controls investigation, institutional relationships may control the process, fragmentation destroys the pattern, delay, the delay, that's a brilliant one, time ticking, the time delay consumes legal rights, that's huge, cost restricts enforcement, narrative reversal relocates the problem again from the institution to the person who reported it. So it's the whistleblower is to blame, not the institution responsible for the alleged wrongdoing. The whistleblower may gradually be reframed. This is widespread. Difficult, unreasonable, repetitive, uncooperative, or problematic. Put in that box and make sure that they stayed in that box because of the way they're treated or they're labelled. So there are all kinds of tactics that are used, that if someone is perceived as a whistleblower, they're sidelined, they're removed from committees, they're not allowed here, there, or everywhere. And then, if they go for promotion, well, you're not on here, you weren't on there, but they were sidelined. So it's incredible how it's done, all of this reframing. The institution is no longer examining the reported wrongdoing, it is managing the reporting person. This is one of the most damaging forms of protective inversion identified in this paper. And I had a look again at this Supreme Court case, so I have new information about this following what I've found out. The paper also examines the important Supreme Court decision in Baranya versus Rosdera Irish Meats Group Limited. Now, I was of the impression that the Supreme Court had decided in a particular way, but that is not the case when I have examined it a second time. So I have looked at it a second time, and the first version of this Supreme Court case I got was factually incorrect. That case established that under the 2014 Irish legislation, as it then stood, a workplace concern did not automatically fall outside whistleblower protection merely because it affected the reporting worker personally. So that was not communicated as such to me in the communication that I had about that case. Quite a different version I was presented with, but I won't go into where that information came from. The case is highly significant because many serious disclosures contain both a personal and a wider institutional dimension. So in fact, the Supreme Court case, was very balanced, but the consequent legislation in the 2022 Amended Act narrowed and took a very, took the version of it that limited, was hugely limiting for the whistleblower. A worker may be personally harmed by unsafe practice, misuse of authority, regulatory failure, or institutional wrongdoing. The personal consequences do not necessarily remove the public interest dimension. The subsequent legislative narrowing of this principle raises important questions about how easily protective interpretations may be restricted while larger problems of retaliation, cost, delay, evidential inequality, and underprotection remain unresolved. I'm shocked. The paper uses an anonymised case study to show how the blind spot may operate in practice. An original concern about alleged wrongdoing may become divided among protective disclosures procedures, grievance processes, employment management, occupational health, external investigations, tribunals, and courts.